Hello and welcome to another episode of Ask Two Lawyers. I'm Keith Davidson.
I'm Stewart Albertson.
You've got questions, we've got answers, and this is what we do. We like to meet Friday, 1 o'clock, and see what kind of questions you have. We have gotten a number of questions on our videos. People leave comments, and we'll be going through some of those. And of course, we invite you now, for those of you watching, go ahead and feel free to put a question in the comments, and we'll get to those as well if we can. Before we get started on answering any questions, though, I did want to talk about a recent development in the Tom Girardi case that happened this week. And of course, our friend Amanda wrote another article. The judge rejected a new trial for Tom Girardi, and the judge decided that Tom Girardi's testimony was consistent with the defense case. And if you recall, the defense had tried to say that Tom Girardi lacked capacity, and so he shouldn't have been tried in the first place. And so that was kind of the pitch to the judge, is even though he was convicted by a jury, his defense team went in and asked the judge to set aside that decision based on Tom Girardi's lack of capacity once again. And the judge was not persuaded. And so the things that I kind of found interesting about this, Stewart, is that the judge focused on a lot of the same things that we kind of focused on during the trial when we were pointing out why we thought Tom Girardi probably did not lack capacity. And so, for example, there was this one exchange between Tom Girardi and the prosecution attorney where she asked him, Mr. Girardi, you spent your career persuading people, right? And Girardi says, I don't know. We will find out. And the attorney said, well, what do you mean by that? And Girardi said, well, I was looking to the jury. And the attorney goes, right, because you're hoping to persuade them to believe you, right? And Girardi responded, I don't want to persuade them to believe me. I want them to believe me. And so that was the type of testimony the judge pointed out and said, that sounds like a conversation that somebody having capacity would have, not somebody lacking in capacity. And so I thought that was kind of an interesting exchange that the judge focused on for the reason as to why she's not going to set aside the jury's decision and grant Tom Girardi a new trial. So what are your thoughts, Stewart?
I think the judge, I don't know if it's the same judge, but some judge, Josephine Staten Parker, I think is her name, she determined previously before the trial that he had capacity to go forward. And so, this is not surprising to me. I mean, when you're a defense attorney, you do everything you can to help a client, which you should. You're supposed to advocate zealously for your client. And that's what Tom Girardi's lawyers are doing here. But they were going to lose this. It was dead on arrival. Once the jury came out with their verdict, that verdict's going to stand. He's a fraudster. He stole money, and he's going to now be held to some extent accountable for it, that he can be held accountable. And of course, his legacy as being one of the greatest lawyers in the United States, that is obviously in shattered. And that's what we're going to remember about Tom Girardi, is that he stole from widows, orphans, and people that couldn't stand up for themselves. And that's what that's his legacy.
Yeah. And it was the same judge who made this decision, who originally made that decision that he could stand trial because he did not lack capacity. So it's not surprising to see that she's being consistent with the rulings. And I don't think that there was anything compelling that would suggest that Tom Girardi lacked capacity. We saw that during the trial. I don't think anything changed from the end of the trial to now. So it would make sense that that's going to be consistent.
Yeah. Again, we feel horrible about the victims that were left in his wake, but, there he is. He's guilty. And for what it's worth, he's 85, 86 years old. So that's where we're at. Yeah.
Yeah. So we'll see what happens at sentencing. That'll be coming up, I think, in the next month, and kind of see where that case goes. So that's the latest on the Tom Girardi trial. So producer Eric, what do you got for us in terms of questions that people have asked us?
Yeah, so firstly, I'm glad we got to touch on the Tom Girardi trial update. If others haven't seen, we've covered cases in Vanderpump Rules world, Reggie Bush versus the NCAA, famous musician Robbie Robertson and his whole estate battle. So we're actively looking for new updates in all of those cases. But if you have any questions, let us know about those as well. But here we have a few questions that were gathered this week, and encourage everyone to type any questions live, but I'll read these on screen per usual. What if a beneficiary is unwilling or unable to hire their own attorney? Can a beneficiary negotiate known surchargeable violations? Excuse me.
Yeah, that's a tough one. I mean, this is America, so you can represent yourself. But it's very, I think, difficult for a beneficiary to go up against a trustee. Most trustees are going to be represented by attorneys. They've got all the money, so they can hire attorneys. And now you're kind of at a disadvantage. So can you do it? Yeah, I mean, conceivably you can. Is it going to be successful? Are you going to get anything out of it? I'm not so sure, because there's a real power differential between a beneficiary and a trustee. And even when we're representing beneficiaries, a lot of times we have to file the lawsuit and we have to litigate for some amount of time before the trustee and their attorney finally are willing to kind of sit down and go to mediation and try to work things out. So it's not a world where you can just say, hey, I think I'm owed, $50,000. I want you to pay it to me. It depends on the trustee, obviously, as well, because the person who is acting as trustee is going to have a big difference as to whether they're going to negotiate or not. But in our experience, most of them don't. So I don't know. What do you think, Stuart?
Yeah, no, I mean, it's a fool's errand to try to represent yourself in any capacity in the legal world. Even as a lawyer, a trained lawyer that knows this area, you shouldn't be representing yourself. So if you're not a lawyer, there's even more reason not to try to represent yourself or to negotiate with a trustee. For one reason, the trustee is simply just going to ignore you more than likely, and you're not going to get anywhere. So as unfortunate as it is, you need a lawyer to help out. And just to give you an example, and I'll talk about myself, the first 5 years or so that I was a lawyer, this is after going through law school and a bar exam and all kinds of craziness. Boy, I hopefully didn't commit malpractice, but I was probably not that effective. And maybe another analogy is, if you've never played the game of chess, chess is a very complex game, and it takes years and years of abuse and being beat in chess to actually, if you can survive the pain of those beatings, to actually get to the point where you can manipulate the pieces and have a strategy and try to move forward. So somebody's saying, I'm going to step into the arena here and I'm going to represent myself as a beneficiary. It's like you stepping in the arena as a brand new chess player against some grandmaster. It's just not a fair game at that point in time. I wish it wasn't that way. I wish our legal system didn't cost as much as it does. So if there are not big issues or big money at stake, those are the harder cases, because you're not going to find lawyers, or you're going to have to spend a lot of money on lawyers for, and not get the bang for your buck because the return isn't that good. So unfortunately, the only thing I can say is don't ever represent yourself in court or represent yourself as a beneficiary. I think you need to, worst case scenario, get a very young lawyer, like when I was a young lawyer, and see if that lawyer will represent you. You're not going to get top-notch legal service, but you're going to get a hungry young lawyer that's willing to work hard and make a name for themselves. And so maybe if you can find that person out there, they'd be helpful to you.
Yeah, I think the chess is a great analogy. Yeah, you cannot sit down at a chessboard and hope to take on a grandmaster. You're going to get beat in 2 seconds. So that's a great way to put it.
Here's another question that came in recently on one of our new videos. It was talking about tangible personal property. It's a part of our new 1 Minute Law School series. All videos are about a minute long, and you can learn a lot really quickly. But someone made a comment. They said they recently went through a probate lawsuit, and never once was tangible property considered during the 3-year-long proceeding. When does tangible property count?
Well, that would be the first case that I'm aware of that tangible personal property didn't come up, because it normally is the deterrent to getting the settlement. And that's because tangible personal property is generally not worth a whole lot from a financial standpoint or a dollar standpoint, but it does have sentimental value in many cases. There's very few cases where there's very expensive art, very valuable art or something like that. You always hear about the gold bullion or the coin collection or the stamp collection that's worth $1 billion. You hear about those things. It's very rare that this stuff is worth anything, but it's where the fight really is vicious at times between the beneficiaries, because there's sentimental value to this stuff, and people they have feelings about this property. And I remember, Keith, in one case I had as a very young lawyer during that first 5 years when I wasn't all that effective, I think we spent $100,000 or so litigating over a old yellow couch that nobody wanted to agree on the division of the yellow couch. Obviously, you can't cut it in half. And I remember being blown away at the time of how vicious both sides were over this yellow couch. They all wanted it because it had been something they had grown up with. And, I don't actually recall what happened with yellow couch, but ultimately that was a deterrent to settling the overall case, which had money involved with, people getting money. So TPP is something that comes up. And if it didn't come up in your case, whoever submitted that question, if they're out there listening, I'm not sure why, because it generally does come up, and it should come up because it should be resolved as part of the global settlement. What are your thoughts, Keith?
It should be resolved, but the problem is it shouldn't be heavily litigated, but it's hard not to because it is sentimental value. And so it's hard to walk away from something, sometimes it's the Rolex that dad had and everybody wants it. And there's only one of them and there's, 3-4 kids. You're not going to be able to split it up. You're either going to have to sell it or one person gets it and somebody else doesn't. And that's why it's such a vicious fight, is because unlike a bank account, which is just personal property, you can divide money all day long. You can't divide the Rolex. You can't divide the yellow couch. You can't divide the tea set. I mean, all the things that we've litigated over the years where people do get very upset about it. And the other thing that's a little frustrating about tangible personal property is most judges just don't want to talk about it. They don't want to mess with it. It's easy to litigate and have a judge decide financial issues, real property, stocks and bonds, money. But for a judge to sit there and make decisions on who's going to get the picture and who's going to get, the framed thing of grandma and all that, most judges they're not interested and they just won't listen to it very much. So it does get frustrating for clients when it comes to the tangible personal property, but it is something that should be discussed. And we often will make it part of any settlement so that people at least get a little something. A lot of times it's the family photographs. That's another thing that, although I guess that's becoming less of a thing now that all the photos are digital. But there's still estates where people have these, old-fashioned photo albums, and they're arguing over it. So those things need to be addressed, but they are very difficult to litigate, and you don't want to over litigate them because you'll cost yourself a fortune.
Here are some live comments and questions from listeners. I'll kind of paraphrase here, but a listener writes in and says, "My father and stepmother set up a trust in August of 2023. The father died a few months later. The drafting attorney is my stepsister's sister-in-law. So maybe you guys have some experience in maybe this and how this might be a conflict of interest or something like that." She later goes on to say, "The trust does not reflect what my dad told me was going into the trust. I also have been given texts that my stepsister sent regarding what my dad had insisted on with regard to me." Do you guys have any thoughts on this listener's scenario?
Well, I want to thank PH for the questions. Sorry you're going through this. It's never fun to deal with these things, especially with the loss of a loved one, and that's generally when these things arise. So, when I look at cases, when people call me, Keith, and they say, "Hey, I'm concerned that, my dad told me one thing, but I'm seeing something else in the trust," I want to know, okay, that's a red flag in my mind. That's a single red flag. I want to know, are there any other red flags? And so PH points out here that not only is it not what her dad told her would be in the trust, but now there's this, my mother's father's sister's aunt, drafted this trust. And I probably didn't get the family relationship right there, but there's some, PH put that in there for a reason. And that is there a conflict of interest there? There may not be like a full conflict of interest there, but there's certainly another red flag. So now we have 2 red flags, right? And so in my mind, Keith, it's worth at least reaching out to whoever the drafting attorney was and saying, "Hey, can you send me your file? Can you provide me your entire file about the estate plan? And I'd like to look through it. And are there any handwritten notes that the estate planning attorney took from the decedent?" Those are helpful in determining whether this is the red flags in this case are less serious and can be explained away, or are the notes missing and have they been shredded? Have they been thrown away? Have they been burned? Is there not even a file? Was it done for free? Was somebody else involved with paying for the creation of the trust besides the settlors? Now we have a third red flag. And so you're looking for these red flag moments. And so PH, I can't answer it any more than that because you're just at the very beginning of this. So it sounds to me like it's something you just need some more transparency on, some more information to determine if it's worth looking further into. What do you think, Keith?
Yeah, I agree. I mean, we do look for the red flags, and we already are seeing 2 of them here. So it's counter to what Dad told you, which that happens from time to time. And I don't know, these people at all, and I don't know this father. There are times when parents will say something that because they just don't want to deal with it, and so they'll say something inaccurate. But more often than not, they mean what they say, and they think that that's what's in the trust. And maybe it's not, and maybe they've been tricked, or maybe they didn't understand it. And then the fact that you have the stepsister, sister-in-law drafting this, that's the same as we have some estates where the parents will use the same estate planner for years and years. And then
And I think we lost Keith there. Can you hear me okay still?
Oh, yeah.
Okay. Why don't we continue on to the next question?
All right. Here's the next question that we gathered. Oh, Keith, we lost you there for a second.
Sorry about that.
You want to finish that thought?
I was just agreeing with Stuart. There's 2 red flags here, and there's more information that we need, but it does beg the question of what's going on here. Something's not right, and that's where you start the case in most of our cases, and you kind of go from there.
I would just tell PH, again, thank you for the question. I would suggest doing a Google search for California trust probate estate lawyers. You'll get a whole list of them on the first and second and third pages, and call a few people and see if somebody's willing to look into this further for you. That would be my suggestion.
And here's our next question that we got was, why does a trustee hire a trust attorney for the end of a trust? Is it typical or only in anticipation of litigation? Is that attorney who represents the trust bound by any fiduciary duty themselves? And I know you guys have talked about representing some trustees in the past, but not something you do much anymore. But what are your thoughts on this?
Yeah, it is normal for a trustee to hire an attorney to work on winding up the trust and being done with it. And so the whole trust administration that has to take place after somebody passes away often does need an attorney to help them do that. And it's not an anticipation of litigation necessarily. It's just something that you would do even without litigation. And then if there is litigation, then you definitely would, trustee would definitely need an attorney, and sometimes a different type of attorney. Sometimes that's when they go from a trust administration attorney to a trust litigation attorney. And so it depends on the different issues that are happening, but it's not uncommon. I'm sorry, Eric, can you put that question back up again? It's not uncommon to have somebody have an attorney at the end. So I wouldn't say that it's only in anticipation of litigation, but it also happens just when you need an attorney. And then the attorney, in terms of fiduciary duties for the attorney, the only duties that an attorney has is to their client, and their client is the trustee. So there's a fiduciary duty to their client, but there's not a fiduciary duty necessarily to the beneficiaries the way the trustee, that's the trustee's duty. The trustee has those fiduciary duties, not their attorney. And so that there's a little bit of a distinction there, which can be confusing at times, but it's not the trust attorney does not owe a duty to the beneficiaries. They only owe a duty to their client, the trustee. The trustee is the one who owes the duties to the beneficiaries, if that makes sense. Would you agree with that, Stuart?
I do, and I think just from my for clarity of my mind, trust administration attorneys, they're out there. They have a function. They're like a primary care physician, and they help somebody who is not a lawyer get through the trust administration process. Now, if tests are taken, to finish my medical analogy, and we find out that surgery is needed, that's the surgeon, the litigator. That's when the litigator can come in. So sometimes trustees have to end up suing people that have harmed the decedent prior to the decedent passing away, or there's a contract that needs to be enforced. And so that's generally where litigators come in. Also, trustees will bring litigators in when they're attacked themselves for their administration of the trust. If somebody argues that they did not invest the trust assets properly, or wasted them, or abused them in some fashion, then they can hire a lawyer to defend themselves against the attack, bearing in mind that if the trust terms don't allow them to use trust money for that, they may have to reach in their own pocket to do that. Now, I don't see many trustees raising their hand up saying, hey, I'm willing to pay my own money to defend myself as trustee. But theoretically, they're not supposed to use the trust assets to do that. They do in most cases. And since most cases settle, it's not that big of a deal at the end of the road, but they're not supposed to do that. So it's not strange to see lawyers on the scene in trust administrations. That happens every day, just like when you go to see a primary care doctor for a checkup. It is a little atypical when there's litigation with a trust, just because something's gone wrong somewhere, and we're needing a judge or a jury to come back and determine who's right and who's wrong. So that is a little extraordinary, and that does happen in, 20%, maybe 15% of cases.
Here's a great question that just came in. Our listener, YM, wants to know, what happens if you're in a will contest due to undue influence, but the person was not mentally incapable? There were other factors that influenced him to sign a will. Is undue influence only for the elderly? So that's a great question. And this person, they're talking about someone who had mental capacity. And usually we hear of, people who are lacking capacity. What do you guys think about this?
Well, YM, thank you for the question. And I would need to know more because I would say that you don't have to be incapacitated to have undue influence exercised against you. Maybe you're just not a very smart person, and I hate to say it that way. Maybe you're not all that educated. Those would be some factors. Those aren't great factors, by the way. Generally, when we're dealing with this, we don't have an incapacitated person, but they're over the age of 65. And people tend to, as they get older, they become more vulnerable to the exercise of undue influence. And so, just to be frank here, we rarely have cases where capacity is that strong of a claim. At the end of the day, in any event, it really comes down to external factors for determining undue influence. And by the way, there's a statute on this. It's Welfare and Institution Code 15-61070 is what I think it is. And it literally explains the different factors that you look at to determine if somebody's susceptible to the exercise of undue influence. And so if somebody is 25 years old, but they're at the end of stage 4 liver cancer, and they're in the hospital and they're very ill and sick, and they've been sick for months and months, and they're on the verge of dying, that person is extremely vulnerable to the exercise of undue influence at that time, regardless of the fact that they're 25 years of age. So that's certainly some factor that you'd want to know. Keith, what are your thoughts?
Yeah, and I think the interesting thing about undue influence is it's not only for the elderly. You could have age, illness. It tends to work best for the elderly. I mean, anybody over 65, but it doesn't have to. And if you have dementia, stroke, Alzheimer's, you can have those things at a relatively early age and still have undue influence. So it's not based solely for elderly people, and it's not based solely for people who lack capacity. And sometimes, I quip that undue influence is capacity light. It's kind of like diet capacity. So with lack of capacity, you have to prove there's an actual lack of capacity. You cannot understand these things. With undue influence, you just have to show that there's a diminishment in the mental functioning that makes it difficult, and maybe impossible, but certainly difficult, to withstand undue influence, to withstand severe persuasion. And that's a very different standard.
YM clarified, Keith, that this was children out of wedlock. And I'm sorry, producer Eric, I'm taking your job. Why don't you clarify the question for us?
Yeah, thanks. So listener went on to say children out of wedlock and stepmother created joint will with dad to disinherit his other children. Seems like, something you guys have probably come across in the past.
Keith, you want to take a stab at that?
Oh, it happens all the time. I mean, anytime you have a later marriage and you have children from different marriages, so stepchildren, essentially, this is where we spend the majority of our time on cases, because that's when you're going to have some major disagreements. And, men and women see these things very differently. I've noticed over the years, back when I used to do estate planning, is that when a man and woman would get married, the man wants to protect the wife and the wife wants to protect her kids. So it's a different dynamic. And that's just the way that I think traditionally, and, we're talking about a generation that's probably a generation above us. That's traditionally, how people viewed the world and how they viewed their roles. And so a lot of times that creates a lot of conflict. And it's not unusual to see a stepmoms say, I want to benefit my kids, but not his kids. And in their mind, they'll justify that. They'll have a reason why that's a good and proper thing to do, even though objectively, certainly for dad's kids especially, that's not a fair thing to do. But there'll be some reason that they can economize in their own mind as to why it is. But we spend a majority of our time on cases dealing with mixed families, stepkids, very, very common.
So just look at the Robbie Robertson case that we've been following. And again, these blended families are difficult. And unfortunately, I have to agree with you, Keith. I'm not making a comment on whether it's right or wrong, but we tend to see a lot of dads' kids getting screwed. And I don't think it's because dads don't love their kids. I just think that's ultimately how it goes. And unfortunately, if we were to get 100 judges and line them up and ask them this question, who are you going to favor? Are you going to favor the new wife or the second wife or third wife or whoever? Or are you going to favor the kids from the first marriage? And unfortunately, without any other evidence that the wife unduly influenced, and it's got to be pretty undue influence. It can't just be, a little bit of this and a little statement here or there. I think that 98 of those judges are going to side with the new wife. Do you agree with that, Keith?
Yeah, it's very hard when you're going against the spouse, because the presumption is, well, of course, spouses want to take care of each other. And in fact, they have a legal obligation and fiduciary duty to take care of each other. And so it's not that odd to say, oh, you mean he left everything to a spouse? Who cares? That's how, judges a lot of times will see it. And of course, the kids of dad say, well, I care because that's, a family house. We grew up in that house. And now dad's leaving it to wife, and then wife's going to leave it to her kids, and we're getting cut out. And so it's a really unfair situation. This goes back to the issue of, well, you should do really good planning to begin with. But, be that as it may, planning either wasn't done or it goes astray because somebody steps in, like in this example, where, a family member comes in and does an amendment that benefits wife. And so here you go. But it is difficult to go before a judge and say, I don't think wife should get the assets of her husband. Most judges are not going to be open to that.
Yeah, something else that's kind of interesting is that I think a lot of times the kids have a very close relationship with their father, and they have no say as into the funeral. They have no say as to where the father's buried. And it comes as a shock to people that the spouse has all of these powers. And I think that, probably in 95% of cases, this is not a problem. But in the cases where the surviving spouse does not get along with her husband's children from a previous relationship, a lot of hurt feelings, a lot of hard feelings can arise after the man passes away.
Yeah, they're not easy to fix. Here's
another question that we got in a comment. It was around Thanksgiving time when we took off for a little break, but someone wrote in to say, if one beneficiary won't sign and trustee needs to file accounting with court, can he distribute to the other beneficiaries that agreed and hold on the beneficiary on the one who won't, or all beneficiary distributions on hold?
Well, it depends. It depends on the trustee's view of it. If I was a trust administration lawyer, I would say withhold all distributions and file the accounting with the court and get the court to confirm it. Because once you have a court order, that is this silver bullet that protects a trustee from liability going forward. Whether the beneficiary who's causing the problem here, it sounds like there's one beneficiary who's just not agreeing, and maybe they have good reason to, Keith, or maybe they just are angry and they want everybody to know it. The probate courts, the judges have a lot of discretion in probate court. And so if I could see a judge looking at a case like this, if it was a very simple case and it was not complex and the accounting wasn't difficult and the facts show that the complaining heir, the complaining beneficiary, is just being difficult and ornery, I think a judge could apply the cost to that complaining beneficiary. Will that happen? Probably not. I think there's a better chance it doesn't happen than it does, but certainly under the right circumstances, I could see a judge doing that. What say you, Keith?
Yeah, on occasion, it can and does happen. I've seen it happen where one beneficiary is being difficult and the judge decides, well, that's fine. The trustee went to court and had the accounting approved, but because you were so difficult, we're going to allocate the cost of doing all this to that one beneficiary. In answer to the question, the trustee could make a distribution to the other beneficiaries who agreed, But I agree with you that they probably wouldn't. And if you were the attorney for the trustee, you would say, don't do that because we don't know how this is going to shake out. So we're going to have to hold all of this until we figure out, what this one beneficiary is up to and what their objections are. But yeah, it's I don't think people fully understand the full width of discretion the judges have in probate court. And they can do any number of things because it's a court of equity. And so they have wide discretion to do what the judge thinks is fair and equitable. Not what you think is fair and equitable, but what the judge thinks is fair and equitable. And the probate code even says the judge has the right to let a trustee off the hook, even if they've breached their duties as trustee. The judge has the right to let them off the hook if the judge thinks that it would be fair to do so under the circumstances. And so it's just kind of wide open for the judge. And that's why presentation of evidence, understanding your argument and your position, presenting it in a persuasive way is so important, because it all is going to come down to what this one judge thinks and feels about this case.
Well, that's all we had for prepared questions. I did just get a text through our phone system, so bear with me, guys. I'm going to read this one aloud, and hopefully you can make sense of it. I think it's a good scenario to talk about. Someone says, Mom passed away 4 years ago and left all her assets and properties to all 5 kids equally. Sibling is trustee and still have not received any documents indicating what exactly is inherited from revocable trust. They ignored requests for family gathering to review. Goes on to say, these red flags and they're being denied info and records for going on 4 years now.
Yeah, that's where you have to file a petition in probate court, because you're entitled to it. Even if you're not in the trust, just as an heir at law, you're entitled to these documents. But that doesn't mean you're going to get them. And sometimes people are difficult. They withhold them for any number of reasons or no reasons at all. And so you have to file a petition in probate court, and then you can get an order ordering them to hand it over. You can also do discovery. So you can do things like subpoenas, document demands, all of those types of things. But if it's been 4 years, that's plenty of time. You should have been informed by now. And if you're not, I think the writing's on the wall. And if you want to find out, you're going to have to take some action by filing in probate court. Do you agree with that, Stuart?
I do. I think that 4 years is too long, and I don't think letters or phone calls or family meetings or smoke signals or text messages are going to resolve this one. There's something that's not right, and I think you're going to have to file in probate court and compel the trustee to account for what they've done over the last 4 years, and also to compel a distribution of your rightful inheritance. So that would be my thoughts there. I also saw that YM had followed up with another question. Producer Eric, am I doing your job again?
No, I'm getting to these in all of a timely manner and trying to flow well. But YM goes on to say, do you know of any case that there were undue influence among wife and husband? It seems like you guys, kind of touched upon this, but have you seen anything like it?
So there's a seminal case.
I guarantee you, Stuart and I are thinking of the same thing right now. Go ahead.
There's a seminal case, Lentz versus Lentz, and I don't remember, it was 2014 or 13 or somewhere in there, but Lentz has been overturned by statute, I believe, to some extent, and so you have to read that case carefully. Keith and I were very happy when Lentz versus Lentz came out, because it gave us the roadmap for attacking a spouse when you're going after them for undue influence. And there's family code provisions. I think it's family code 721 or something like that talks about the fiduciary relationship between spouses. I hate saying spouses because it should really be spices if we're being correct in the English language. But anyway, when there's this fiduciary relationship, and I think, though, from my gut, what I think based on our experience in dealing in going after spouses in blended family situations, the court almost always sides with the surviving spouse. And I think the surviving spouse in these cases gets a little bit more influence, maybe not quite slam dunk undue influence against the husband. But I think they're given a little bit more rope to work with than, say, a sibling or anybody of another type of relationship other than a spouse. So spouses get a lot of room to talk with their other spouse, the deceased spouse, about what they want. They can even encourage them to leave money to themselves, to their children, or to whatever, and it won't be that big of a deal. Whereas if a sibling did that, that would be something that may be worth looking further into. What do you think, Keith?
Or a neighbor or a caregiver, something that's unnatural. I mean, that's really what it comes down to, is when you have something unnatural, it's more suspect than when it's, objectively just natural. But yeah, the great thing when Lentz came out, the great thing about it at the time is it raised a presumption of undue influence as between spouses because of the fiduciary duty that spouses owe to each other. But that was later overturned by statute. So now that is not a presumption of undue influence. And so it was encouraging because Lentz was the first case that at least gave us some ammunition on these cases where you have stepchildren and you could at least have something to show that maybe the spouse did unduly influence the other spouse. That's changed now because of the statute that took that away. But Lentz is still an instructive case, and it's certainly one that we would cite to and look at if we had this situation, for sure.
Let me give YM just some examples of cases we've had in the past where we've had this blended family situation and we're going against the surviving spouse. What evidence are we looking for, Keith? We're looking for evidence that there's a pre-existing estate plan that consistently gives to the children, his children, and also provides for the spouse. And it's consistent for a number of years. And then there's a change that is made 2 or 3 or 4 days before the person passes away while they're in the hospital with a tube down their throat, coming out of anesthesia. A lawyer is summoned by the wife. There's emails, contemporaneous emails between the wife and the lawyers, where the wife is instructing him what to put in, the lawyer to put into the trust. That case now starts to make sense that, hey, we're going to bring that forward. And by the way, that case will settle 99 times out of 100, just because the wife, that evidence is just so overwhelming at that point in time. The wife has to settle. But even then, you have to be careful, because these are the most favored beneficiaries, in my opinion, are spouses. And so you have to be very careful as you play that game.
Yeah, there certainly could be some examples like that where, you have some facts that help you out.
All right, I want to get to this. This is a live text in. I'll put it on screen here for you guys. Can you confirm for a trust account that is funded, shouldn't there be some record indicating clearly what trust is protecting? Trustee says that doesn't exist, claims no inventory of assets exist either. Here's a part 2 of this that I think is kind of juicy. After 3 years, saw some bank statements of trust that trustee used funds to pay for her own living expenses for over a year that I could make out: mortgage, cable, electric, oil, insurance, etc. So it seems like they're, more that fraudulent trustee that we've talked about in the past.
Well, and of course, the trustee has to inventory the assets. They have to show you what the assets are. Part of the trustee's job is to marshal the assets, means to collect them. And then any accounting is going to have a list of the assets at the beginning of the accounting period. Here's the assets that we had. Here's the value that we think they are, the value that they were, either based on appraisals or because they're bank accounts or, stocks and bonds. But for a trustee to say, well, I'm managing a trust, but I don't have a list of assets, that's a violation of their duties. They're just not doing it right. They have to give you that disclosure. And so again, if they're not giving you that disclosure, it's time to take action. You're going to have to file something in court in order to get that information. And then you can issue subpoenas directly to the banks and find out what's going on here. What do you think about that, Stuart?
Yeah, no, I agree with all of that. And a lot of this comes down to just, getting more transparency. And so when somebody is not wanting to give you transparency, that's a big red flag. Why don't they want to give me transparency? Why are they saying there aren't any assets when there are? And then, of course, apparently this person saw some expenditures on behalf of the trustee that are questionable. So that's your leverage. And, it is kind of fun, I'll say, when you do find a bad acting trustee, and these are only for the really fraudulent trustees that I feel good about this, where they have used trust assets to buy personal things on or pay their credit card statement, or do something that you normally wouldn't get a chance to get from a trustee, but then you send a subpoena to the credit card company. And think about all the things that we spend on our credit cards, Keith. Would we want those things made public? I know none of them are earth-shattering, and none of them should be too embarrassing. But I don't want people to know what kind of underwear I buy. I don't want people to know, what restaurants I go to, and what theaters I go to, what movies I go to. These are things that are personal to me. And boy, if you are subpoenaing this information on a trustee who used trust assets to pay for this stuff, you get their attention quickly.
Yeah, how much I spend at Bed Bath and Beyond is none of your business, and I just happen to like tea towels, and that's my thing.
Yeah,
exactly.
Here's another question that just came in. Can a trust attorney closing the trust allow trustee continue to breach? Is that clear to you?
It is.
Yeah,
it is. And want to thank Casey. It sounds like Keith was getting ready to answer that, so I'll let him answer.
Well, it's always frustrating. People have this ideas of why is the trustee's attorney allowing the trustee to do this? It doesn't really work that way. So the trustee is the one who's in charge. They're the ones who take the actions. The trust attorney is there to give them advice. So the trustee's attorney says, you should do this and you should do that and you shouldn't do this other thing. But it's not the attorney's job to stop the trustee or block them in any way, because they can't. They don't have that power. There's no power to do that. And so it's just like any other attorney-client privilege. Stewart and I can advise our clients that you should do this, but don't do that. But it's the client who gets to decide whether they're going to listen to that advice or not. And ultimately, it's the trustee who has to decide to listen to the advice or not. And then it's the trustee who's going to be liable if they don't take good advice or if they take actions that are in breach of the trust. But it's a little bit of a misunderstanding to think that the trustee's attorney has the power to stop the trustee or, do some sort of thing to block the trustee. The trustee attorney just can't do it. That's not their role, and they don't have the power to do it.
And Casey, thank you for the question. I would just say that, you're based on your question, you believe that there's a breach of trust. So there's always going to be an argument on the other side. There's not a breach of trust. So there's somebody that has to make that determination. But one thing I would say is that if I was representing a trustee and they were taking money and using it inappropriately for themselves, I would caution them and advise them and put in writing for them to stop doing that. Now, that's just a writing that goes to them. It doesn't go to all the beneficiaries. And if they continue doing it, I would withdraw, because I would not want to be a lawyer working on that case. So I don't have any power to force the trustee to stop the bad behavior, but I do have a power to not represent them going forward. And it's probably not a good look when you see a lawyer moving off of the case that was helping out with the trust administration. That rarely happens. I've seen it happen a time or two in my career where a trustee was acting so badly that the attorney had to withdraw, and it ended up, of course, hurting the trustee's position in the case. So that could potentially happen. But just based on your question, you're assuming there's a breach of trust, and there very may well be a breach of trust. But I think there's lawyers on the other side that this is a gray area breach of trust. And so I'll give you an example. If the trustee is using money to keep the lights on in the house that they lived in with the decedent prior to the decedent dying, and the trustee is administering the trust out of the house that they were already in with the decedent for a year, and they're still paying for the electric bills, the TV bills, and all of that, I think a judge is going to say it's reasonable for a certain amount of time after the decedent died to keep these bills being paid. But at some point, the trustee needs to start paying for them themselves, because they're essentially still in the house. So you could see where a beneficiary would be very upset about a trustee using money for cable and electricity and those types of things. But I think a judge is going to give them a couple months to get things all squared away. Technically, they shouldn't be using any trust assets for that. But I think judges, again, a lot of discretion. They're going to look at this as a reasonableness standard. And if a trustee is being reasonable, they're not going to get too excited about that. If a trustee's going to Vegas and putting it all on black or all on red and betting your money, that's something that's going to get all of us excited. Judges, lawyers, beneficiaries, and probably a judge is going to step in there and stop that behavior from happening on the spot.
Well, I think that's all the prepared questions, and maybe we'll hang in here for a couple more minutes if anyone has anything else. But Yeah, Keith, anything else to add?
I don't have anything else to add for today's episode. I want to thank everybody for the questions. When you put questions on the comments of our videos, we do pick them up, we do look at them, and we prepare them for the next Ask Two Lawyers. So please continue to do that. You also have the telephone line that's below me here in the screen. Feel free to send a text, or you can call and leave a message, and we're happy to answer those questions as well. And of course, feel free, you should also subscribe to our YouTube channel and set the notifications so that you know when we're going live, so you can be noticed next time that we're here and answering questions.
And Keith, we're doing lives every Friday, barring holidays, every Friday at 1 p.m. Pacific time. And we'll come on here for an hour and a half if we need to. And we're not giving legal advice. We're trying to help people get into the ballpark to answer their question and figure out if they need legal representation or not. They should anybody who asks questions should seek the advice of a competent lawyer so that they can determine for themselves what action to move forward with.
Yep, and check out the YouTube channel as well. Like Keith had mentioned, we upload at least 1 or 2 videos every week and a lot of other short videos. So give us a follow there. And if you're listening on the podcast platforms, rate the show so we can continue growing. Otherwise, we'll see you guys next week.
Next week.
All right. Thanks, everyone.